History of a lawsuit. Number 1. Parties. In a lawsuit, the person suing is the plaintiff, and the person against whom he makes his claim is the defendant. There may be more than one plaintiff or more than one defendant. If A and B jointly own an automobile which is damaged by C, both A and B must join in an action against C. It is improper for either A or B to sue alone, since it is their and not his or her car. Number 2, proper court. When a person desires to go to court to enforce a right, his attorney must bring the action in the right court. A decision by the court on a case not within its jurisdiction has no legal effect. Number 3, form of action. The plaintiff's lawyer determines the form of action to bring. At the old common law, which is still in effect, there was frequently a difficult problem because there were many forms of action, and the plaintiff would lose their case if his attorney selected the wrong form. Beginning 100 years ago, many states attempted to overhaul their procedure and reduce the number of forms of action. Accordingly, a number of states thus provided that an ejectment should be brought for the recovery of all interests in land, a replevin for the recovery of any personal property, an action of a subsit for any contract claim, and an action of trespass for any tort claim. There were still special actions, such as mandamus, to compel a public corporate officer to certain kinds of acts, and quo warranto, to question the authority of a public corporate officer to do an act, or the authority of a corporation to exercise a particular power. And there were still separate criminal and equity courts. In a number of states, a separate court within jurisdiction over wills, decedents estates, or descendants' estates, and trusts began to appear. This is all statute law. Other states combined the forms of action and provided that all actions at law should be brought under the name of civil action, or a civil action for damages without regard to the original common law name. Some states even abolished the distinction between actions at law and actions in equity, so that the civil action included all non-criminal proceedings. Number 4, commencement of action. In the old common law courts, an action was commenced by filing an order with the keeper of the court records to issue a writ to the sheriff. This writ of summons ordered the sheriff to inform the defendant to appear before the court on a particular date. This method of commencing an action is still followed in many states. By way of contrast, an action in a court of equity was begun when the plaintiff filed with a court a complaint, in which he stated the facts about which he complained. No writ was issued, but a copy of the complaint was served on the defendant. In many states and in the federal courts, the reform of recent years has extended this equity practice to all legal actions. These actions are today commenced by the filing of the plaintiff's complaint. Some states still preserve the former distinction between law and equity, while others give the plaintiff the option of commencing the action by either method. Number 5, service of process. The defendant must be served with a process, commonly called a writ, notice, or summons, to inform him that the action is pending against him. Number 6, pleadings. After process has been served on the defendant, the plaintiff is ready to proceed. If he has not filed with the clerk of the court a written statement of his claim or complaint, he will now do so. After the complaint is filed, a copy is served on the defendant. the defendant must make some reply, generally within 15 to 21 days. If he does not, the plaintiff ordinarily wins the case by default, and the judgment is entered in his favor. Before answering the plaintiff's complaint, the defendant may make certain preliminary objections. Some choose to demur. He may assert, for example, that the action was brought in the wrong court, or that he had not been properly served. If the objection is sustained, the case may be ended, depending upon the nature of the objection, or the plaintiff may be allowed to correct his mistake. The defendant may also raise the objection, sometimes called a motion to dismiss or demurrer, that even if the plaintiff's complaint is accepted as true, he is still not entitled to any relief. If the defendant loses his objection, he must file an answer which either admits or denies the fact averred by the plaintiff. For example, if the plaintiff declared that the defendant made a contract on a certain date, the defendant may either admit that he made the contract or deny that he did so. The fact that he admits making the contract does not end the case, for the defendant may then plead that at a later date the plaintiff and the defendant agreed to set it aside, or that some type of violation took place. Without regard to whether he pleads such a new matter, the defendant may generally assert a counterclaim or cross-complaint against the plaintiff. Thus, he may argue that the plaintiff owes him money or damages and that this liability should be offset against any claim which the plaintiff may have. After the defendant files his answer, the plaintiff may generally file preliminary objections to the answer. Just as the defendant could raise objections, the plaintiff may, in certain instances, argue that the counterclaim cannot be asserted in the court in which the case is pending, that the answer is fatally defective in form, or that it is not legally sufficient answer. Again, the court must pass upon the preliminary objections. When these are disposed of, the pleading stage is usually over. Generally, all pleadings in an action may raise only a few or perhaps one question of law, or a question of fact, or both. Thus, the whole case may depend on whether a letter admittedly written by the defendant amounted to an acceptance of the plaintiff's offer, thereby constituting a contract. If this question of law is answered in favor of the plaintiff, a judgment will be entered for the plaintiff, otherwise for the defendant. By a way of contrast, it may be admitted that a certain letter would be an acceptance if it had been written, but the defendant may deny that he ever wrote it. Here the question is one of fact, and the judgment is entered for the plaintiff if it is determined that the fact happened as he claimed. Otherwise, the judgment is entered for the defendant. If the only questions involved are questions of law, the court will decide the case on the pleadings alone, since there is no need for a trial to determine the facts. If questions of fact are involved, then there must be a trial to determine what the facts really are. Number 7, pretrial procedure. Many states and federal courts have adopted other procedural steps that may be employed before the trial, with the general objective of eliminating the need for a trial, simplifying the issues to be tried, or giving the parties information needed for pretrial preparation. The procedural process for pretrial involves the following. A. Motion for judgment on the pleadings. After the pleadings are closed, many states permit either party to move for a judgment on the pleadings. When such a motion is made, the court examines the record and may then enter a judgment according to the merits of the case as shown by the record. B. Motion for summary judgment. In some states, a party may shorten a lawsuit by bringing into court sworn statements and affidavits which show that a claim or defense is false or a sham. This procedure cannot be used when there is substantial dispute of fact concerning the matters to be proved by the use of the affidavits. C. Pretrial conference. In many states, either party may request the court to call a pretrial conference, or the court may take the initiative in doing so. This conference is in substance a roundtable discussion by a judge of the court and the attorneys in the case. The object of the conference is to eliminate matters that are not in dispute and to determine what issues remain for litigation. The pretrial conference is not intended as a procedure to compel the parties to settle their case. It not infrequently results, however, that when the attorneys discuss the matter with the court, they recognize that the differences between the conflicting parties are not so great as contemplated, or that one side has less merit than was at first believed. In consequence, a settlement of the case is agreed upon. D. Discovery. The federal rules of civil procedure and similar rules in a large number of states now permit one party to inquire of the adverse party and of all witnesses about anything relating to the action. This includes asking the adversary or the adverse party the names of the witnesses, asking the adverse party and the witnesses what they know about the case, examining, inspecting, and photographing books, records, buildings, and machines, and making an examination of the physical or mental condition of a party when it has a bearing on the action. These procedures are classed as discovery. Under the prior practice, except for the relatively unusual situation in which a party could obtain information before trial by filing a bill of discovery in equity, a party never knew what witnesses would appear in court or what they would say, or what documentary evidence would be produced. E. Depositions. Ordinarily, a witness testifies in court at the time of the trial. In some instances, it may be necessary or desirable to take his testimony out of court before the time of the trial. It may be that he is aged or infirm, or is about to leave the state or the country, and will not be present when the trial of the action is held. In such a case, the interested party is permitted to have the testimony called a deposition of the witness taken outside the court. The taking of the deposition is accomplished by having the witness appear before an officer authorized to administer oaths, who places the witness under oath to tell the truth. Questions are then asked the witness as at a regular trial. The answers are recorded, generally by a stenographer, and a transcript is made of the answers. These are ordinarily read by the witness, signed by them, and the questions and answers are sent by the officer in charge of the taking of the deposition to the court in which the action is pending. Number 8. Determination of facts. A. The trier of facts. If the legal controversy is one which in the common law days would have been tried by a jury, either party to the action has the constitutional right to demand that the action be tried by a jury. If all parties agree, however, the case may be tried by the court or judge alone without a jury, and in some instances referred to as a master or a referee appointed by the court to hear the matter. In equity, although there is no constitutional right to a jury trial, the chancellor or equity judge may submit questions to the jury. There is the basic difference that in such cases the verdict or decision of the jury is only advisory to the chancellor. That is, he seeks it for his own information, but is free to ignore it if he wants to do so. That is why in most modern cases today, the judge or chancellor in that position can overrule the decision of the jury, because most juries today have been taken and made advisory juries. In contrast, the verdict of a real jury in an action at law is binding on the court unless a basic error is presented by the facts. When new causes of action are created by statute, such as the right of an employee to obtain workman's compensation for an injury arising in the course of his employment, without regard to whether the employer is negligent, there is no constitutional right to a trial by jury. The trier of facts may accordingly be a judge without a jury. He is then a chancellor. This includes a special administrative board or agency, such as a workman's compensation board. B. Basis for decision. The trier of fact, whether a jury, a judge, a referee, or a board, can only decide questions of fact on the basis of evidence presented before it. Each party offers evidence in support of his claim. The evidence usually consists of the answers of persons to the questions in court. Their answers are called testimony. The evidence may also include some real evidence, that is, tangible physical objects and things, such as papers, books, and records. In some cases, such as a damage action for improper construction of a building, the trier of fact may be taken to view the building so that a better understanding can be obtained. The witness who testifies in court is usually a person who had some direct contact with the facts in the case, such a person who saw the events occur or who heard one of the parties say something. In some instances, it is also proper to offer the testimony of persons who have no connection with the case when they have expert knowledge and their opinion as experts are desired. A witness who refuses to appear in court may be ordered to do so by subpoena. He may also be compelled to bring relevant papers with him to court by a subpoena ducis tecum. If he fails to obey the subpoena, the witness may be arrested for contempt of court. In some states, the names of the order upon the witness and the procedure for contempt have been changed, but the substance remains the same. Number 9. Conduct of the trial. The conduct of a trial will be discussed in terms of a jury trial. Generally, a case is one of several assigned for trial on a certain day during a certain trial period. When the turn of the case is called, the opposing counsel seat themselves at tables in front of the judge and the jury is drawn. After the jury is sworn, the attorneys usually make opening addresses to the jury. Details vary in different jurisdictions, but the general pattern is that each attorney tells the jury what he intends to prove. When this step has been completed, the presentation of the evidence begins. The attorney for the plaintiff starts with his first witness and asks him the questions that he desires and that are proper and relative to the case. This is called the direct examination of the witness, since it is made by the attorney calling his own witness. After the direct examination has been finished, the opposing counsel asks the same witness such questions as he desires in an effort to discredit the testimony. This is called cross-examination. Sometimes the opposing counsel may call other witnesses to impeach the credibility of the witness. After the cross-examination has been completed, the attorney for the plaintiff may ask the same witness other questions to overwhelm the effect of the cross-examination. This is called redirect examination. This step, in turn, may be followed by a further examination by the defendant's attorney called recross examination. After the examination of the plaintiff's first witness has been concluded, the plaintiff's second witness takes the witness stand and is subjected to an examination in the same way as the first. This continues until the plaintiff's witnesses have been called. Then the plaintiff rests his case and the defendant calls his witnesses. The pattern of examination of witnesses is repeated, except that now the defendant is calling his own witnesses and his attorney conducts the direct and redirect examination, while the questioning by the plaintiff's attorney is cross and recross examination. After the witness of both parties have been examined and all the evidence has been presented, each attorney makes another address, a summation. to the jury, in which he sums up what he has proved and suggests to the jury that it reach a decision in favor of his client. Number 10. Charge to the jury and the verdict. The summation of the attorneys is followed by the charge of the jury to the jury. This charge is a resume of what has happened at the trial and an explanation of the applicable law. At its conclusion, the judge instructs the jury to retire and study the case in light of his charge and then return a verdict. This, of course, is when the judge is a chancellor. By his instructions, the judge leaves to the jury the problem of determining the facts, but states the law that they must apply to such facts as they may find. Now remember, this is chancellery court. The jury then retires to a secret deliberation in the jury room. Number 11, taking the case from the jury and attacking the verdict. At several points during the trial or immediately after, a party may take a step to end the case or to set aside the verdict. A. Voluntary non-suit. If a plaintiff is dissatisfied with the progress of his case, he may wish to stop the trial and begin again at a later date. In most jurisdictions, he can do so by taking a voluntary non-suit. B. Compulsory non-suit. After the plaintiff has presented the testimony of all his witnesses, the defendant may request the court to enter a non-suit on the ground that the case presented by the plaintiff does not entitle him to recover. C. Direct verdict. After the presentation of all the evidence at the trial, either party may request the court to direct the jury to return a verdict in his favor. When the plaintiff would not be entitled to recovery even though all the testimony in the plaintiff's favor were believed, the defendant is entitled to have the court direct the jury to return a verdict for the defendant. The plaintiff is entitled to a verdict in his favor when, even if all evidence on behalf of the defendant were believed, the jury would still be required to find for the plaintiff. In some states, the defendant may make such a motion at the close of the plaintiff's proof. D. New trial. After the verdict has been returned by the jury, a party may move for a new trial if he is not satisfied with the verdict or with the amount of damages that he has been awarded. If it is clear that the jury has made a mistake, or if the material evidence that could not be discovered sooner is available, the court will award a new trial and the case will be tried again before another jury. E. Judgment non obstante veredicto. If the verdict that is returned by the jury is clearly wrong, as a matter of law, the court may set aside the verdict and enter a judgment contrary to the verdict. This in some states is called a judgment non obstante veredicto, again, under the auspice of chancellery court, or as it is abbreviated in the judgment NOV. Number 12, judgment and costs. If a new trial is not granted or if a judgment NOV is not entered, the court enters a judgment following the verdict. Generally, whoever is the winning party will also be awarded costs in the action. In equity actions, or those that had their origin in equity, and in certain statutory proceedings, the court has discretion to award costs to the winner, to divide them between the parties, or to have each party bear his own expense. Costs ordinarily include the cost of filing papers with the court, the cost of having the sheriff or other officers of the court take official action, the statutory fees paid to the witnesses, the cost of a jury fee, if any, and the cost of printing the record when this is required on appeal. They do not include compensation for the time spent by the party in preparation for the case or in being present at the trial, the expense in going to his attorney or to the court, the time lost from work because of the case, or the fee paid by him to his attorney. Sometimes when a special statutory action is brought, the statute authorizes the recovery of a small attorney's fee. Thus, a mechanics lien statute may authorize the recovery of an attorney's fee of 10% of the amount recovered, or a reasonable attorney's fee. As a general rule, the cost that a party recovers represents only part of the total expenses actually sustained in the litigation. Number 13, appeal. After a judgment has been entered, the party who is aggrieved thereby may appeal. This means that a party who wins the judgment but is not awarded as much as he hoped, as well as the party who loses the case, may take an appeal. The appellate court does not hear witnesses. It examines the record of the proceedings before the lower court, that is, the file of the case containing the pleadings, the testimony of witnesses, and the judge's charge to see if there was error in law. To assist the court, the attorneys for the parties file arguments or briefs, and generally make an argument orally before the court. If the appellate court does not agree with the application of the law made by the lower court, it generally sets aside or modifies the action of the lower court and enters a judgment as it concludes the lower court should have entered. It may set aside the action of the lower court and send the case back to the lower court with the directions to hold a new trial or with new directions to enter a new judgment in accordance with the opinion filed by the appellate court. Number 14, execution. After a judgment has been entered or after an appeal has been decided, the losing party generally will comply with the judgment of the court. If he refuses to do so, the winning party may take steps to execute or carry out the judgment. If the judgment is for the payment of a sum of money, the plaintiff may direct the sheriff or other judicial officer to sell as much of the property of the defendant as is necessary to pay the plaintiff's judgment and the cost of the proceedings and the execution. Acting under this authorization, the sheriff may make a public sale of the defendant's property and apply the proceeds to the payment of the plaintiff's judgment. In most states, the defendant is allowed an exemption of several $100s in certain articles, such as personal clothing and tools of his trade, including his vehicle. If the judgment is for recovery of specific property, the judgment will direct the sheriff to deliver the property to the plaintiff. If the judgment directs the defendant to do or to refrain from doing an act, it is commonly provided that his failure to obey the order is a contempt of court punishable by fine or imprisonment, or both. Number 15, a concluding word. The foregoing reviews indicate that a lawsuit may be a long proceeding, a long process, because the winning party does not recover all of his expenses. Even he may have less than he would have had if there had been no lawsuit. The losing party has his own expenses and costs to bear, in addition to any judgment for damages that he must pay to the other party. Knowledge of the law before you enter into any transaction, or guidance by one who has such knowledge, may save you much difficulty and expense.